I recognize the member for Vancouver Fairview.
Thank you, Honourable Speaker. And this is an important issue to speak to. It's an important bill to speak to, but I wish, as I'll point out in my statements, that I could see a lot more in this bill of worth to speak to. But it is important to talk about some of the measures that this bill addresses, as well as some of the measures that it doesn't address. Let me begin by referencing some statements of the Minister. The Minister said in her remarks that the provisions in this bill in response to the inquest, in response to the tragedies that befell the workers at Babine and Lakeland and their families, that it was the least we can do, and it seems like very little. Nothing that anyone could do in this legislature or anywhere else could return the individuals who lost their lives to their families or return life to those individuals that was taken from them. But it saddens me in many ways that, in fact, this bill is the least we can do in a very real sense. There's much more that could have been done. There's much more that should have been done, and frankly, much more that should not have been done many years ago that set the stage for the kind of workplace culture, the kind of lack of a safety culture, a meaningful safety culture in so many workplaces around British Columbia that could lead to the kind of conditions where employers cut corners, where they took chances, where they hoped that they could get away without taking the most strong precautionary measures that they could take. And there's also, and I say this from experience, a culture that develops in regulatory agencies. If the message is to go easy on regulation, that's exactly what will happen. And that message will become entrenched, and that habit will become entrenched. And over time, there'll be a proclivity to do less rather than more, because that is the message that people are getting from their superiors, and that is, in fact, the culture that was built up over time at the Workers' Compensation Board, beginning very shortly after the election of this Liberal government in 2001. Honourable Speaker, I don't doubt that members opposite believe that every worker should return home safely. I've never talked personally to a worker for whom it wasn't critically important, as critically important as the fact that they could go to work and bring a paycheck home to put food on the table for their families and themselves, that it was also critically important to them that they could return home safe, that they could return home healthy so they could enjoy life with their families and their families could enjoy life with them. And too often, much of the work that we do, particularly in the resource industries, although not only in the resource industries, is inherently dangerous work. There's aspects of the work around which particular care must be taken to prevent workplace injury, lifelong debilitating injury, as well as death. And yet, Honourable Speaker, there is some irony. In fact, there's considerable irony that we're debating this bill this afternoon after spending considerable time debating a very short 13 or 14 or 15-word bill called the Red Tape Reduction Act. Because, Honourable Speaker, red tape reduction was a signal position of this Liberal government when first elected in 2001. There was a promise to cut red tape by 1/3. And it wasn't a focus on cutting unnecessary red tape or forms or streamlining or redundant or unnecessary regulation. It became, under the minister responsible for deregulation, Kevin Falcon, how can we meet that goal? How can we remove anything that any employer says gets in the way of them doing business and making a profit? And a singular focus of this Liberal government in the period following 2001 were the workplace safety and health regulations. And it wasn't just the regulations themselves, it wasn't just changing a focus from regulations that had been carefully crafted in response to real risks in the workplace that had resulted in real injuries and real deaths of very many individuals, regulations that had resulted from research that showed where the greatest risk to workers existed, whether it was falling practices, whether it was practices in mills, whether it was lockout procedures, whether it was fall protection. Regulations weren't crafted simply because somebody living in an ivory tower or in a vacuum decided they wanted to make it as difficult as possible for employers to do business. No, that isn't how they were crafted. In many cases, in fact, in most cases, they were a result of a protracted, comprehensive regulation review process that included industry experts, occupational hygiene and health experts, representatives of employers, representatives of workers, and having been part of that process for a number of years, Honorable Speaker, I know that during that period of time, there were some pretty fierce arguments about what was appropriate and some compromises made. But in the end, the strongest regulations that were possible in that circumstance, in that time, were agreed upon in order to protect workers. And they had been for decades prior as well. They were there for a reason, and they were there because the best employers, the employers who understood that a safe workplace was a productive workplace over the long term, that it made no sense in terms of either retaining skilled workers or attracting new ones, or not being liable for lifelong pensions, which of course no longer exist, thanks to this government, that it was better not to have accidents happen if they could be prevented. And that was at the root of safety programs, that was at the root of accident investigations, that was at the root of regulations that were put in place to protect workers and to educate workers and employers and supervisors around safe work practices. Honorable Speaker, after this government was elected, and I say this because this bill, in part, in significant part, is a response to the coroner's inquest, which specifically identified some failures of the Workers' Compensation Board, and I say Workers' Compensation Board because that is and continues to be the legal name of the organization. The Workers' Compensation Board's ability for compliance, investigations, and worksite visits and enforcement procedures underwent a 45% reduction in inspections and a 49% decrease in written orders. Employer penalties were down by 36%. Those are figures from 2005 in the 4-year period. Honorable Speaker, having been at the board as a member of the panel of administrators, having participated in developing workplace regulation, I know something about the dynamics that happen there. I know that at the board level and with senior executive members of the Compensation Board, when we talked about developing and promulgating a workplace culture of safety in order to protect workers, to bring down the accident rate, to prevent fatalities, so that they could return home safe, and so that employers would not be paying ever-increasing premiums to cover lost work time, lifetime pensions, or death benefit payments in the worst-case scenario to families, that it took an understanding of all parties that the primary goal was to keep the workplace and workers safe. And that also entailed a workplace culture at the WCB where people understood as inspectors and compliance and enforcement officers and occupational hygiene officers that yes, part of their job was to educate employers and people in the workplace about how to make it safer, but that was not to be a substitute for firm measures for firm enforcement, for acting very rapidly and quickly on observed deficiencies. But when I was at the board, people who were responsible for setting the culture and setting the tone spoke very openly that if you spend a number of years developing and reinforcing a culture among the people who work at the board on a day-to-day level, the ground troops, if you will, that what they were to do was to limit orders, to limit penalties, and to limit enforcement, and simply try to encourage employers to do a better job, to turn a blind eye in some cases to violations and give people a second chance, that you couldn't turn that ship around in a day. You couldn't turn that ship around in a week. You couldn't even turn it around in a month or a year, because what you've done is you've effectively trained people in a way to do their job, and they grow to understand that that's what's expected of them. An honorable speaker, that can and does have tragic results, whether it's training a cadre of adjudicators to look for any reason whatsoever to turn down a claim or limit the duration of a claim or deem somebody suitable for a job that doesn't exist so that they can be paid off with a much reduced amount of money to cover lost earnings for the rest of their lives, or whether it's taking workplace inspectors and saying, let the employer know that you're coming before you come, meet with them in the back room without worker representatives present, and try to cajole and encourage them into doing a better job. Honorable Speaker, that has an impact. That creates a culture, and Honorable Speaker, the Minister can say whatever she wants about this bill and the intent of it and what the result of it might be as a response to the Lakeland and Babine explosions and the deaths. The truth is that she was a cabinet member in 2001 when this government set a radically different tone for the Workers' Compensation Board, a radically different tone for the acceptance of claims, a radically different tone for the payment of pensions, and a radically different tone for worksite inspections, for involvement of workers, for compliance orders, for enforcement, for regulations that were prescriptive in the case of conditions in the worksite that led to serious injury and death, and instead set a tone that said, we will not stand in the way of what the people in the business community say to us are obstacles or things they cannot work with, and will hope for the best. That's what happened in 2001. That's what happened for a number of years, and until there were some extremely tragic clusters of death in the forest industry, it wasn't until then, after 2005, that this government replaced some of the regulations it had stripped out of the occupational health and safety regulation body in British Columbia, because it was clear that it wasn't working, that there would be tragic results, and they had to do something. And that is exactly what's happening today with this bill, which is not to say that there isn't and there aren't clauses in this bill worthy of support, but let's be honest about how we got to where we were, and let's also be honest about what is missing from this bill. Honorable Speaker, according to people in the construction trades, lost time accidents and fatalities in general construction, heavy construction, and road construction jumped from 7,000 in 2001 to 20,700 in 2006, a 300% increase over a period of time when the workforce grew 60% from 100,000 people to 160,000 people. Honorable Speaker, that is one of many examples of the result of actions that were taken by the Liberal government shortly after taking office that took an already less than adequate regime of compensation and workplace protection and made it worse, made it dangerously worse. So, Honorable Speaker, everybody's attention, was caught by the tragic explosions at Lakeland and Babine and the deaths. So, the families wanted a public inquiry. What they got was a coroner's inquest. What we have today is some limited responses to the coroner's inquest. But, Honorable Speaker, if we were really serious in this place about doing the best we could in every circumstance to protect workers who are at risk of serious injury or death, we would have a public inquiry. We would have called a public inquiry. We would have looked at what happened at Lakeland and Babine. We would have looked at inadequacies in the Workers' Compensation Board inspection regime. We would have looked at those warning signs that were ignored by both the mill owners and people at the Workers' Compensation Board. We would have looked at observations by workers about hazardous conditions that weren't acted upon, but we also would have looked further back, I hope. I hope we would have looked carefully at a history that led up to that culture at the Workers' Compensation Board of failing to act quickly and decisively on significant evidence that there was a risk, a serious risk, a risk that ultimately led to a tragic circumstance of explosion that destroyed people's lives, destroyed their families' lives, gutted their friends, gutted the communities, and left a tragic legacy. Honorable Speaker, the minister said this is the least we can do, and she's right. It is the least we can do. We could do much better. We could have done much better in the days following the explosions. We should have done much better. Let me turn, Honorable Speaker, to some examples. If the minister would like me to address the bill, I would simply point out to the minister through you, Honorable Speaker, that when she introduces an act to amend the Workers' Compensation Act and says that this is the least we can do for the families, that she has opened the door to comment on every action by this government, every action by the Workers' Compensation Board, every failure to regulate, every failure to inspect, and every failure to enforce that has led to today, that led to the events at Lakeland and Babine. And so, Honorable Speaker, let us turn to Lakeland and Babine and what this bill purports to do to address the issues that were raised. Honorable Speaker, the Premier, when she visited Burns Lake after the blast, said that it may be a task, but we're going to be there, we're going to step up. She said from Prince George, we will be there to support you. Honorable Speaker, incident investigation reports into the mill blast concluded that the explosions, which were obviously fueled by dust, were preventable. They noted that in the weeks and months prior to both explosions that WorkSafe BC did not enforce the combustible dust provision of the Occupational Safety and Health Regulation. Honorable Speaker, I repeat my comments earlier. There was a culture developed at the Workers' Compensation Board in direct response to actions taken by this government to deregulate workplace safety and health that led to a culture that went easy on inspection, went easy on enforcement, in this case, just went terribly, terribly, terribly wrong. In 2014, the Criminal Justice Branch, the Crown, declined to lay charges against either company. They stated that the Workers' Compensation Board improperly collected evidence and failed to sufficiently flag wood dust as a risk prior to the blast, which helped the company's reasonable due diligence defense. Honorable Speaker, Premier steadfastly refused to convene a public inquiry, saying that a coroner's inquest is the appropriate forum to provide closure and some accountability to the families. It has not provided closure. It has not provided accountability. Instead, we have a few minor amendments to the Workers' Compensation Act. Honorable Speaker, why did the Workers' Compensation Board fail to fulfill its fiduciary duty to protect workers by not taking prompt action against wood dust? The United Steelworkers have released an issues management briefing note from inside the board that was prepared during the period between the Babine and Lakeland explosions from February 27, 2012, and the note reveals hesitation on the part of the agency to enforce the existing combustible dust provision of the Occupational Health and Safety Regulation in the wake of the Burns Lake explosion because it feared industry backlash. It feared industry backlash. The incident investigation report into Lakeland seems to reflect this. It notes that the combustible dust provision was not enforced prior to the April 22, 2012 explosion. Honorable Speaker, when an organization with the resources, the mandate, and the responsibility of the Workers' Compensation Board fails to take action on something as fundamentally important to protecting lives and safety and communities as the combustible dust provision, it doesn't happen in a vacuum. It happens in a context, and in this case, the context was over 10 years of a culture created by this government that downplayed workers' safety regulations, downplayed putting enforcement and inspection officers in the field and giving them a mandate to do their job, because this government considers that red tape. This government considers that an impediment on business and profit, instead of the necessary actions that employers must take to prevent British Columbians workers from injury and death. Honorable Speaker, much was heard by the jurors in the inquest about actions that should have been taken and weren't taken. Much was heard about actions that have been taken in other jurisdictions that recognized combustible dust as a significant hazard and acted on it. For example, American regulatory authorities had recognized the dangers of combustible dust before the BC explosions. In 2005, the U.S. Chemical Safety Board issued a report on the dangers of combustible dust, and in 2007, the Occupational Safety and Health Administration developed a combustible dust national emphasis program in the U.S. From the Lakeland inquest report, Honorable Chair, and I quote, "Expert evidence from chemical engineers as well as the U.S. Chemical Safety Board combustible dust video provided information about the combustibility of dust, and it was noted that the danger of dust explosions and fires is well known in the USA." But even after the inquest, Honorable Speaker, even after the inquest, the McAdee Review and the Dybel Review, there remains no clear explanation about why the government agency in charge of keeping mill workers safe in BC did not respond with haste, did not respond using the precautionary principle, did not respond to growing workers' concerns that were raised around the increased levels of dust from beetle-killed wood, or about taking steps to educate and call on employers through directives, through orders, to implement best practices and research about combustible dust. Honorable Speaker, there are things in this bill that will help, but there are things not in this bill that would help more, and I wish that we were talking about them. I wish we were praising the minister for finally recognizing that some things need to change, that the culture of the Workers' Compensation Board needs to change, that there needs to be a priority and emphasis on the precautionary principle, that there needs to be a culture of no tolerance for risk to workers' lives, period, full stop. And that it won't change overnight, so it will take extra actions. Honorable Speaker, my experience over many, many years of working with worker representatives on occupational health and safety committees, of training them, of training health and safety activists in the labor movement about understanding their rights, their right to participate, which is a right that was hard won in Canada. And the right to participate means that there should be joint occupational safety and health committees, not as an option or as something to be downplayed, as was done by the Liberals in 2001 until the tragic deaths in the logging industry when they were reintroduced a few years later. And the right to participate also means that when there is an incident, or as it's called often on the work site, a near miss, when there is an incident or an accident, it needs to be investigated. It needs to be investigated by people knowledgeable about the work, knowledgeable about the workers who are doing the work, and knowledgeable about the workplace. And on that issue, the role of workers' representatives must be on an equal footing with employers' representatives. That's how workers will have confidence, and that's, frankly, Honorable Speaker, how prevention officers and occupational safety and health officers at the Workers' Compensation Board will know if the issue is being addressed or if it's being swept under the rug. So, Honorable Speaker, the inquest recommended that steps be taken to clarify the meaning of the term participation in Section 174 of the Workers' Compensation Act to ensure full and meaningful participation in the investigative process by both the employer and the worker representative. And as my colleague from Vancouver Hastings has said, we need to clarify that that is exactly the minister's intent in the amendments that are brought forth, because there has been concern expressed by the labor movement that the wording of Section 7 actually runs counter to the intent of the recommendation that was made by the coroner's inquest, that it could limit and circumscribe a worker's participation in accident investigations. It may have been, Honorable Speaker, that the intent was to expedite the process, but it should not be done, and there must be nothing in this act that could, in this bill, that could be interpreted, if passed, to circumscribe the rights of worker representatives to participate fully in accident investigations and incident investigations. To do so would turn the clock back on workers' health and safety rights decades in this province, decades. And we will want to make sure that that is not the case. Honorable Speaker, let me summarize my comments. Much more needs to be done to reverse the trend that was started by this government in 2001. If this government is serious about embracing workers' health and safety and protecting workers and ensuring that we are never dealing with the consequences of a tragic incident such as happened at Lakeland and Babine ever again, they need to look back over their full 14 years in office and see what can be done to reintroduce measures that were in place for decades to protect workers' health and safety and to build a healthy, vibrant, knowledgeable, and committed body of workplace safety inspectors and an enforcement team. That's at the crux of it. They have to change the culture of the board. And they have to also look very carefully at these amendments and ensure that nothing is contained in them that further circumscribes the right of workers to know about the risks to which they may be exposed and to participate fully in every level of addressing risk on an ongoing basis in workplaces to ensure that workers never again face the risk of serious injury death in circumstances which were known and which could have been addressed before the tragic incidents happened. With that, I'll take my seat. Thank you.
Thank you, member.